Ethical considerations of artificial intelligence, AI, and the law. Navigating the intersection of emerging technology and jurisprudence with the rise of artificial intelligence is not merely a technical evolution, but a profound challenge to our existing ethical and statutory frameworks. The rapid deployment of these systems has outpaced the slow-moving machinery of the law, creating a regulatory gap that leaves both developers and users in a precarious position. We must grapple with the reality that our current precedents were never designed to handle entities capable of autonomous decision-making. Therefore, the legal community must take a proactive role in defining the ethical boundaries that will govern AI to ensure justice remains a human-centric endeavor. The problem of accountability and liability. The traditional concept of torts relies heavily on the ability to identify a responsible party who owed a duty of care and subsequently breached it. With artificial intelligence, the black box nature of neural networks complicates this lineage, as it is often impossible to trace a specific harmful output back to a single human error. If an autonomous system causes physical or financial harm, the lawyer's primary hurdle is determining whether the fault lies with the coder, the data provider, or the end user. This ambiguity necessitates a shift towards strict liability frameworks or the creation of new electronic personhood categories to ensure victims are adequately compensated. Bias and the erosion of due process. Algorithmic bias represents one of the most significant ethical threats to the principle of equal protection under the law. When AI systems are trained on historical data that reflects societal prejudices, they do not just learn patterns, they codify and automate discrimination. In criminal sentencing or hiring practices, these prejudices in code can deprive individuals of their rights without the transparency required for a fair trial. From a legal standpoint, challenging a machine's logic is far more difficult than cross-examining a human witness, which fundamentally threatens the integrity of due process. Intellectual property and the rights of creators. The tension between AI training and intellectual property law has reached a boiling point, raising questions about the very definition of authorship. Generative models scrape vast amounts of copyrighted material to produce new works, leading to intense litigation over whether this constitutes fair use or mass infringement. Lawyers must now argue over whether a machine can transform a work in the legal sense, or if it is merely a high-tech derivative engine. Protecting the economic rights of human creators while fostering innovation requires a delicate legislative balance that we have yet to achieve. Data privacy and informed consent. Data is the lifeblood of AI, yet the methods by which this data is harvested often skirt the edges of ethical consent. In a legal context, informed consent implies that a person understands exactly how their information will be used, which is rarely the case with complex AI training sets. The right to be forgotten becomes a technical impossibility when an individual's data is permanently baked into a model's parameters. We are seeing a shift where privacy is no longer just a personal right, but a collective asset that requires aggressive litigation to protect from corporate overreach. Transparency and the right of explanation. For a legal system to function, decisions must be explainable. A judge cannot simply rule because the math said so. The ethical demand for transparency is not just a technical preference, but a legal necessity for administrative law and regulatory compliance. If a citizen is denied a loan or a government benefit by an algorithm, they have a right to know the specific factors that led to that outcome. Without a right to explanation, we risk moving toward a technocratic society where the law is a series of opaque, unchallengeable commands. The threat of professional confidentiality. In the legal profession itself, the use of AI tools introduces significant risks to the attorney-client privilege. Uploading sensitive case files to third-party artificial intelligence platforms can inadvertently waive confidentiality if the data is used to train future iterations of the model. Lawyers have an ethical duty to competence that includes understanding the security risks of the technology they employ. Failure to vet these tools properly could lead to malpractice claims and the compromise of a client's most sensitive legal secrets. Environmental and resource ethics. While often overlooked in legal circles, the environmental impact of training massive AI models carries its own set of ethical and regulatory burdens. The sheer volume of energy and water required to maintain data centers raises questions about corporate social responsibility and environmental law compliance. As Green New Deal-style regulations expand, companies may find themselves legally liable for the carbon footprints of the digital infrastructure. Lawyers must begin advising clients of the sustainability of their tech stacks as part of a comprehensive risk management strategy. Weaponization and international humanitarian laws. The development of lethal autonomous weapon systems presents the most dire ethical challenge to international law since the advent of nuclear weapons. These systems threaten to lower the threshold for conflict by removing human soldiers from the immediate risk of the battlefield. Legally, the chain of command becomes blurred when a machine decides when to use lethal force, potentially violating the Geneva Conventions. Establishing international treaties to govern AI and warfare is a matter of global urgency that requires deep legal and ethical synthesis. Corporate governance and fiduciary duty. Directors and officers of companies deploying AI have a fiduciary duty to act in the best interests of shareholders, which now includes mitigating AI risk. This involves not only preventing financial loss, but also ensuring the company does not engage in unethical artificial intelligence practices that damage brand reputation. Boards of directors must now be briefed on algorithmic audits and ethical impact assessments as part of their standard oversight. From a litigator's perspective, the failure to implement an ethical AI framework could soon be seen as a breach of the duty of care. Human agency and the risk of over-reliance. There is a profound ethical risk in the automation bias that leads professionals to trust a machine's output over their own expert judgment. In the legal field, a lawyer who relies on an AI-generated brief that contains hallucinated or fake case law is failing their ethical obligation to the court. We must maintain a human-in-the-loop requirement to ensure that machines remain tools rather than masters. Preserving human agency is essential to maintaining the moral authority of our legal institutions and the legitimacy of the judicial process. The digital divide and access to justice. Artificial intelligence has the potential to bridge the access of justice gap by providing low-cost legal information, but it also risks widening the divide between those who can afford premium systems and those who cannot. Ethically, we must ensure that AI does not become a tool that only the wealthy can use to navigate the complexities of the law. If the best legal AI is locked behind a massive paywall, the principle of equal justice for all becomes a hollow promise. Legal aid organizations and the bar must work together to ensure AI is used to democratize, not commodify, legal expertise. Consumer protection and deceptive practices. The use of artificial intelligence to create deepfakes or highly persuasive misinformation campaigns poses a direct threat to consumer protection laws. When AI can mimic a human voice or face to commit fraud, The legal definition of identity and misrepresentation must be expanded. Regulators are already looking at how to mandate the disclosure of AI-generated content to prevent the mass manipulation of markets and public opinion. Lawyers will be at the forefront of suing entities that use these dark patterns to deceive the public. Labor rights and the future of work. The displacement of human workers by AI is not just an economic issue, it is a labor law crisis in the making. As artificial intelligence takes over tasks previously performed by paralegals, junior associates, and even some specialized experts, we must redefine the rights of displaced workers. Ethical considerations regarding just transitions and severance in the age of automation will likely result in new collective bargaining challenges. Lawyers must advocate for a framework that values human labor while acknowledging the inevitable shifts in the employment landscape. Algorithmic surveillance and civil liberties. The integration of artificial intelligence into surveillance technology, such as facial recognition, creates a constant state of digital frisking that threatens the Fourth Amendment. Ethically, the law must draw a line between public safety and the total erosion of anonymity in the public square. Without strict warrants and oversight, AI surveillance could be used to suppress dissent and target marginalized communities with surgical precision. Litigating these civil rights will be the defining battle of the next decade of constitutional law. The ethics of artificial empathy. As AI systems become better at mimicking human emotion, they enter a gray zone of psychological manipulation that current laws are ill-equipped to handle. AI companions or therapists collect some of the most intimate data imaginable, creating a unique vulnerability for the user. From a legal perspective, we must ask if these systems owe a fiduciary-like duty to the humans they interact with. Preventing the exploitation of human emotions for commercial gain is a burgeoning area of ethical concern for consumer advocates. Global standardization versus sovereignty. The ethical regulation of artificial intelligence is complicated by the fact that the internet knows no borders, yet laws are inherently territorial. We face a race to the bottom where companies may relocate to AI havens, where it lacks ethical standards and minimal oversight. Legal experts must work toward international harmonization, similar to maritime or space law, to create a baseline of human rights protections. Without global cooperation, the ethical enforcement of AI standards will remain fragmented and largely ineffective. Toward a jurisprudence of AI. In conclusion, the ethical considerations of AI demand a fundamental reappraisal of what it means to be a person, a creator, and a citizen under the law. We cannot afford to be passive observers. We must be the architects of a legal framework that prioritizes human dignity over algorithmic efficiency. The path forward requires a synthesis of technical literacy and moral philosophy, ensuring that as our tools become smarter, our justice remains wiser. Only through rigorous advocacy and thoughtful regulation can we ensure that artificial intelligence, AI, serves the public good rather than undermining the foundations of our society. To learn more about our own legal practice in the areas of business, technology, and artificial intelligence, we welcome you to visit our website and contact our law firm to schedule a confidential consultation. Thank you.